Go time.
Oh, okay.
Good morning, everyone. This is the Board of Appeals March 12th meeting. We're holding it virtually using the WebEx platform. Let's begin by reviewing our Aloha Etiquette. One person will speak at a time with no side conversations. Mute your device, please. That'll improve the audio quality for all of us. Raise your hand and wait for the recognition by the chair before speaking. I'll have support from my staff to notice you. If my head's down, you will be noticed. Speak slowly and clearly and as close to your microphone as is appropriate. Limit the distractions, that's mobile phones, devices, small children, dogs. And if required, we'll take breaks on the hour. So I'd like to begin by introducing the members of the Board of Appeals. I'd like to begin with Stacy Aguiar. Stacy? Can we hear you?
Good morning. Good morning,
All right, thanks.
Chair.
Good morning. Thanks, Stacy. This is also our audio check, so speak to me. A new member, Matson Davis. Do I have
Good
Matson?
morning, everybody. Good morning, everybody.
All right. Great, Matson. Thanks. And Richie Henderson II, new board member. Richie?
Good morning, everybody. I hope you can all hear me.
Yes, all good. Springer K?
Hi.
Hi, Springer. Justin Lee? Justin?
Hi.
Hi, good morning.
Can you hear me?
Yes, thanks. Neil Thomas?
Good morning, everybody.
Hi, Neil. We normally are advised by Diana Mellon Lacey, a counsel to the board, but today we have our pinch hitter, Jay Yoshimura.
Good morning, everyone.
Staff to the board, April Supernut to my right. Keiko Mercado is our WebEx host. Rob Leisure is our Kona co-host for WebEx. And behind me and watching you wave at me is Melissa Dacayan Salvador. She's our secretary to the board. I'd like to begin by announcing that we had a couple of matters today, but one has been withdrawn. Wood Valley Capital LLC, BOA 19-000233 is continued until July 9th, 2021. We do have the matter of Mr. Sturz. Is there anybody from the public that has items on the agenda that wishes to testify? And did we have any testimony submitted?
But I'm aware.
Okay, the chair notes there's been no testimony submitted and there doesn't seem to be anybody from the public seeking to testify. So we'll begin by the new business. This is the matter of James Sturz, BOA 20-000256. It's an appeal of decision by the planning director dated December 20th, 2019, regarding a denial issued for a short-term vacation rental registration. That was STVR 19-361-627, and a non-conforming use certificate, which is NUC 19-1462. The location of this is 53-3947 Pratt Road, Kapa'au, Hawaii 96755, and the TMK is 5-3-006-030 parcel. Let's see. So, at this time, let's see. I'd like to have the parties to the matter recognize themselves. Please state your name for the record. Mr. Sturz, are you there? Mr. Sturz? This could be a short hearing.
For the record, Mr. Chair, John Tsai, PD Corporation
Yes.
Counsel on behalf of the County of Hawaii Planning Department. Also present is Planning Director Zendo Kern. Morning, everybody.
Good morning, Mr. Planning Director and Mr. Mukai. We have the party representing the Planning Director. Do we have Mr. Sturz available?
Chair, I'm not sure. Mr. Sturz might be in the Kona office.
Yes.
Yeah.
Noriko, can you hear us? Noriko, do we have Kona? I see them on the upper left, are they not, or is that me?
Bottom right.
Bottom right.
Keiko, can you confirm if we're having difficulties, or Rob, if we're having difficulties in Kona?
Rochelle's following up on it as well.
Yep, I think someone's running into the conference room to double check right now. We've tried to request unmute, but no luck. Hold on 1 second.
Disconnected.
Connected, right?
Hello, we're not hearing in the corner room. Are you
Go
there?
on.
Can you tell them to pause? Yes, we can hear you.
Okay, they're having some audio issues in the Kona conference room. They can't hear. So hold on 1 second.
We may have you call in just on the phone here.
Too short.
Yeah. We're having, we're just not able to. Somebody's on the phone next to
They can't hear you or the meeting. That's the problem. They're getting no sound in here.
We can hear you now, Rob.
Call in on the speakerphone, so at least they can communicate that way. Let's try that, okay? Okay, hold on. Noriko, can you go to the meeting invite and tell me the number to call?
Rob, we can hear you now.
They can't hear us, all right?
Oh,
I think that's what they said.
okay.
Maybe we should have a signer. Somebody behind me with big gesticulations.
Something's wrong with their speaker.
Oh. Okay, we're gonna test. Hi, Noriko, do you hear us?
I'm Noriko.
Oh, sorry, Keiko. Sorry, Keiko, do you hear us?
Yes, we can hear you now. Chair, can you
Okay,
hear
great.
them?
Yes, we can. All
Awesome.
right. So then, Mrs. Sturz, just you can mute yourself.
Okay.
Should be able to use that.
Okay, so we're not looking at this, right?
Okay.
So, I'm sorry, this is the speaker or this is the speaker?
Yeah, they're supposed to be connected, but I don't see the light on. So this one is here, and the mute button is right there. Okay.
Okay.
Great. So we're going to put them on mute for the moment. Was there a test prior from the Kona room, and it worked fine?
Okay. You're on it. Yeah. Could we raise the volume?
Okay, so. 2 minutes. These are the volume.
Good morning.
Good morning, Mr. Sturz.
Yes, this is Mr. Sturz.
Hi, good morning. Were you able to hear the introduction by the other party, the planning director and his counsel?
No, I heard none of it.
Okay, so Mr. Sturz, would you please identify yourself for the record?
My name is James Sturz.
Thank you. And you are the appellant. And for the county, could you please reintroduce yourself to Mr. Sturz?
Good morning, Chair and board members. John Ukai, Deputy Corporation Counsel on behalf of the County of Hawaii Planning Department. Also present is County of Hawaii Planning Director Zendo Kern.
Morning.
Good morning. Let's begin by establishing that the notice issues, I've been advised by staff, according to our BOA Rule 8-11D, has been served, and that the appellant has complied with the requirement. Thank you, Mr. Sturz. Are the parties ready to proceed?
I am.
Yes.
Yes.
Okay. I'd like to note for the record that we had a pre-hearing conference on February 6th of 2021, and the parties stipulated to the record on appeal, which all the members of the board should have in front of them. I'd like to make note that the planning department has a dispositive motion in front of the board. This motion will be heard now. Mr. Sturz, I didn't note that you filed a response to the planning department's motion. Have you received the motion and reviewed it?
I read it last night. I apologize. I am not an attorney, so all of this is new to me, but I have read his motion and or the planning department's motion, and I'm prepared to orally respond to it.
All right, thank you. Well, so board, at this time, we're going to hear this motion, and we will begin by having the planning department present their motion to dismiss.
Yes, thank you, Chair. John Mukai, Deputy Corporation Counsel. Mr. Sturz filed his petition with the Board of Appeals to try to vacate the planning director's decision of December 20, 2019. And that's been included as Exhibit D to our motion. What he wants the board to do is invalidate the planning director's denial of his STVR and non-conforming use denial and approve registration of both. However, Mr. Sturz's property is on state agriculturally zoned land, and Mr. Sturz simply does not have a remedy under this board's jurisdiction. And we pointed out the Hawaii County Code section 24.4.16.1e, agricultural lands. And in state land use, agricultural district, a short-term vacation rental non-conforming use certificate may only be issued for single-family dwellings on lots existing before June 4, 1976. Mr. Sturz here just does not have a remedy because the granting of an STVR in the state land use agriculturally zoned district is prohibited by the Hawaii County Code and also by the recent State Land Use Commission decision, which has not yet been published. In this case, the statutory language is clear. And normally a court or this board's duties in interpreting a statute is to give effect to its plain and obvious meaning. And where language is when construction of the language by this court should be interpreted to give effect to its plain and obvious meaning. Now, Mr. Sturz, I believe, will argue that the land that his parcel was on was agricultural prior to June 4th, 1976, and the subsequent subdivision of his parcel did not cause any substantive changes. However, this argument would lead to absurd and nonsensical results because under this theory, every subdivision on agriculturally zoned lots post pre-76 would qualify for an STVR if its subsequently subdivided. This would produce a simply absurd result. We point out that at one time, the property where Mr. Sturs was probably zoned Lava 1 at some point in time. So finally, there just cannot be an automatic approval of Mr. Sturs' STVR and non-conforming use certificate because the planning department may have missed its 90-day decision. But the Hawaii County Code expressly prohibits an STVR non-conforming use certificate on state agriculturally zoned land after June 4, 1976. Mr. Sturs' argument would again lead to absurd conclusions that the planning department's internal rules would somehow override the Hawaii County Code and allow improper uses in certain zoned areas. Mr. Sturs may disagree with the Hawaii County Code, but the Board of Appeals is not the proper venue for him to challenge the Hawaii County Code. He can do it elsewhere. So as such, on behalf of the Hawaii County Planning Department, we would respectfully request that County of Hawaii Planning Department's motion to dismiss or in the alternative for summary judgment be granted.
Thank you, Mr. Mukai. Mr. Sturs, please, a response.
So if I may use Mr. Mukai's words in the most congenial fashion, I find his memorandum to support dismissal to be absurd and nonsensical itself. First, the statutory language in the county code is exactly the opposite of plain and unambiguous, contrary to what Mr. Mukai argues. In fact, it is so vague and hard to decipher that it led this very planning department, as well as the Linda Roseville parties, to seek a declaratory ruling to help interpret it. And that interpretation has not been published, and I'm not sure that anyone in this hearing can honestly and accurately say exactly what it entails. Second, the argument in my original appeal that our parcel was agricultural prior to June 4th, 1976, and that its subdivision did not cause any substantive changes to it is neither absurd nor nonsensical. It is a simple statement of fact. Mr. Mukai can say that drawing a line on a map creates changes to the land it is supposed to represent, but that goes against several laws of science and seems both absurd and nonsensical in itself. It is yet another instance of how Hawaii's county code is itself ambiguous and vague, and it also sidesteps the separate issue of whether there are any grandfathered rights. Just in one further response to Mr. Mukai's statements, to say that my land might have once been zoned as Lava 1, my parcel sits in North Kohala. Kohala Mountain is extinct and was believed to have last erupted 60,000 years ago, and I don't think it would have been zoned as Lava 1 60,000 years ago by anyone. Thank you.
Thank you, Mr. Sturs. Planning Department, do you have rebuttal?
We have nothing further, Mr. Chair. I think we would rest on our argument and the motion and exhibit submitted.
Thank you. At this time, the board can ask questions of the parties. Any board members?
This is Springer Kay. I have a question for the planning department. I wonder if you could explain the definition of creating a lot and answer the question, when you subdivide a lot, is it considered to be one old lot and one new lot, or two entirely new lots? And is that uniformly applied in subdivision code?
Yeah, hi Springer. Zendo Kern here, Planning Director. I'll answer the question. So typically, if a lot was to be subdivided, all of the lots would be then newly created lots, is the way that the Planning Department has always interpreted it. That'd be a different case if it was a lot consolidation and re-subdivision where the lines were maybe changed, and it started with 3 lots and the lines got altered to still create 3 lots. There was an interpretation earlier on around that was clarified that would not constitute the creation of a new lot. But if the lot was to be subdivided in a subdivision action based on Chapter 23, those would be deemed the creation of the lots, and whatever date that final subdivision approval was granted, that would be the date that the lot was created.
Thank you, that's helpful.
Thank you.
Yes? Are you on mute? Neil?
Muted.
Are you able to unmute yourself? No?
Keiko or Rob, can you please unmute?
There we go. There we go.
There we go.
Now I think I'm unmuted.
Okay.
So, sorry for the delay. I had a question for the planning director. It has to do with the 90-day rule. If I understand the planning department's reasoning, it's that it doesn't matter if they miss the deadline that says they have to approve an application within the 90-day period. Because if they miss the deadline and what is being applied for can't be approved anyway, then the deadline doesn't really matter. Could you confirm that I'm understanding this correctly and elaborate perhaps?
Yeah, that's a correct understanding of what we're saying, is that if it wasn't if it was against what was codified in law and we missed and that deadline was missed, it would be somewhat irrelevant. It would kind of like saying submitting an application for a supermarket on ag land, and let's say there was a 90-day time period. Supermarkets aren't allowed on ag land, and if the planning department missed that 90-day time period, would we allow a supermarket to go on ag land? Not necessarily, right? So that's where we stand with that interpretation of the 90-day and the law.
Thank you. Does the appellant have anything further to say on that topic?
I do. Back to the subject of the statutory language itself being vague and impossible to decipher, the only thing that is clear and where there has been a lot of clarity in all of the planning department's rules and regulations is the procedure for property owners to apply for STVR and NUC registration. And that included an 18-page application form, multiple mailings, multiple fees, multiple documents and affidavits that had to be submitted, and above all, multiple deadlines that had to be met. And it created a lot of very specific statutory language describing exactly how it had to be done. So if the planning director is now saying none of that matters, because the only thing that matters is something else, then I think we're at the point where it's not clear what rules the planning department is following at all. And if that is the case, the planning department needs to completely rewrite the codes and the rules that it follows, because the director is saying they don't matter. And I'm not sure we're all at that point today, but that is something for the Board of Appeals to address.
Thank you.
Yes. Yes, Justin.
My question is for the planning director. Prior to the 2013 subdivision, was the agricultural lot in question zoned for single-family dwelling?
I would have to follow up on that. I can get you an answer in a couple minutes on that. My understanding is no, but I want to make a fair statement. So if you wouldn't mind, we can get into some other questions and I'll get that answered.
Okay, thank you.
So to clarify, Justin, are you asking whether there was more than one lot that pre-existed 2013? That this argument could be made that the current use is on a pre-existing lot?
I guess what I'm getting at is, my understanding is the lot on which Mr. Sturs' property lies was subdivided in 2013. So I'm going at to what the zoning of the lot was prior to 2013. My understanding it was zoned agricultural, but whether it was single-family dwellings were allowed on that prior lot before the subdivision.
All right. Well, the planning director seems to be preparing an answer. Is there anybody else with questions for the parties? I'd like to remind the board of the standards that we operate under for an appeal such as today. We need to find that the planning director's decision is in violation of the code or any other applicable law, or was clearly erroneous as we review whether there was a reliable, probative, or substantial evidence on the whole record, or whether the planning director's decision was arbitrary, capricious, or characterized by an abuse of discretion. So what we're discussing here with the dispositive motion is essentially it's the first part of that standard, where there was a misunderstanding by the director of applicable law. The argument being made by the appellant has to do with the characterization of improvements on properties zoned agriculture before and after June 1976. The second part of the argument being made by the appellant has to do with whether a subdivision is a substantive change in the property. And so for this motion, purposes of this motion, at the beginning of the arguments, we should focus on this. Mr. Planning Director, have you returned?
Mr. Chair, I have returned, but we're still, Deputy Director Jeff Darrow is gathering that information right now and reviewing the files in our GIS system, and we'll have information on that momentarily. Happy to answer anything else in between.
Okay. So one thing that Mr. Darrow would be searching is the subdivision record of 2013 and how many lots were created and whether this particular parcel was one of those lots. Presumably, was there do you know if there was a development, a farm dwelling, or a single-family residence on the larger property prior to 2013?
That's what Deputy Director Jeff Darrow is researching right now, as well as maintaining that the property did not change any type of zoning during that period of time as well. That it had maintained its agriculture status through.
Good, thank you.
Thank you.
Okay, yes, members of the board, do you have any further questions for the parties? Yes, hi Jeff, are you here?
Yes.
Thank you. Mr. Darrow, could you please answer the question regarding the nature of the property prior to 2013?
So,
please, could you identify yourself for the matter?
Sure, my name is Jeff Darrow with the Planning Department. The property in question has been a part of a number of subdivisions in the past. I'm looking at, when I click on a particular parcel, I can identify that there's been 4 subdivisions that have occurred prior, including the one that happened in 2013 that is identified as subdivision 11001075 revised 2, which means it was revised twice. The zoning of the properties is not changed as a result of the subdivision. It just creates new lots. So a good example would be if you had lots 1, 2, 3, and 4, or 1, 1, and 2, and they were subdivided to create new lots, it could be completely new lot numbers, or it could be 1-2-A or 1-2-B, but it would have a new lot number, and therefore you would have a newly created lot. So again, this particular subdivision was not the first subdivision of this particular property. There were several before this.
And Mr. Darrow, would you also give us the history on the zoning? Was this always agriculture zoning from the inception of zoning, or there was a zoning change?
There has been no zoning change. The current zoning is Ag 20, and it's always been Ag 20. As far as farm dwellings, that's a little more difficult to be able to get that information right now. As far as I could search each of the properties and find out if there's dwellings permitted on them, but it might take a little bit more time.
Mr. Darrow, this is the chair. Is it possible to provide us with a inception date for parcel number 30? This is 5300630.
That would be the two. Yeah, that would be the newly created lot of TMK 53630 would be the approval date of subdivision 11 00175 revised 2, and let me get you that date. Let's see here. Sorry for the delay. These maps are quite large, and you've got to locate the actual assignment. The date for that was July 19th, 2013.
So parcel number 30 did not exist prior to that date?
It would be as far as the TMK, that would be a little bit different. I'd have to go back and see if the TMK itself, because you have a difference between a parcel number and a lot number. They may have used the same parcel numbers, but the lot number has definitely changed.
Okay. Just for clarity purposes, when you look at the map, can you determine what was the earliest parcel number?
I'd have to do a little bit of research. I can do that by looking back at some old maps and be able to find the original TMK for the entire area for that those parcels. If you just give me a minute or two, I can go track that down.
And to elaborate on that a little bit, Sheriff, I can have a little attitude?
Yes.
When a subdivision occurs, there's really no such thing as like a root lot. At the end of it, it is subdivided and all lots become part of that subdivision action. So the rationale and justification saying there was a root.
Is there any reference?
Mr. Binder, we're getting a lot of crosstalk.
Yeah, that's stopped now. So with the subdivision, there's no real root lot. When the subdivision action occurs, it's created all of those lots in that subdivision action. Again, if this was a lot consolidation and re-subdivision based off of pre-existing lots of record or old grants, that would be a completely different story, and those lots would have been existing during the as far back as they could be dated, many years back. But again, there's no, so the argument to say there was a root lot that existed prior to that within the subdivision that would then be pre-76 doesn't really exist in our methodology of doing subdivisions.
And has this been tested? Mr. Planning Director, has this been tested, this theory or this practice? Do you know if anybody's challenged whether the root lot qualifies as a pre-existing lot?
That I'm not sure.
Thank you.
Thank you.
Mr. Sturz, do you believe you have the root lot?
I believe that, or I can say for sure that I occupy a portion of it. That is obvious on face value. That's all that I can say. To argue as Mr. Kern does, that the planning department doesn't have the methodology for checking this points to a deficiency in the planning department's methodology. Doesn't change the underlying facts.
Board members, any further questions? Yes, Neil?
Chair, I just want to be clear on one point regarding this 90-day business. It says the planning director shall issue a decision within 90 days unless the appellate has agreed to some longer period. I'd just like Mr. Sturz to confirm whether he agreed to extend that 90-day deadline at any point in time.
I was never asked to extend the 90-day period, and I have never agreed to extend the 90-day period. I want to make that very clear.
Thank you. Planning Director, do you agree with that fact?
And
that's, yeah, no argument on that.
Thank you.
And I'd actually like to go back to the previous question about the root lot. I think you could make an argument, the planning department, a person could make an argument that a lot becomes a new lot when it receives new things that it didn't have before, such as county water. In my case, we have no county water. We were not connected to county water. We were set up without county water. So I'm going to, I think, make the argument that, in fact, we do have the root lot, and that all the other lots around us may actually have been lots that were spun off from ours.
Do you have anything to support that? Is that just a statement you're making?
No, it's an assumption that I'm making because I do see that the other lots were given water lines, and because ours was not, this is a theory that I have. No, I can't prove it. However, there's no obvious evidence that I'm aware of to say that it's not true. It may be true.
Mr. Chairman?
Yes.
This is Jeff Darrow again with the Planning Department. We had one of our staff planners do the research on the parent lot. The parent lot is usually the lowest number in a series of numbers. The parent lot for this particular subdivision was parcel 25. Out of that came parcel 26, 27, 28, 29, and 30. So the argument that this parcel 30 is the parent lot would be incorrect. Additionally, just, to clarify on the difference between a pre-existing lot prior to 76 versus after 76, you can have a particular parcel that can be quite large. In this case, to be able to subdivide, you either had to have pre-existing lots, which would allow you to consolidate and resub. But if you had the ability, because of your size, to be able to create new lots based on zoning, which means for every 20 acres, you could create a new lot. And that lot was established after 76. What that ends up doing is creating the ability Number one, it creates higher density, obviously. Number two, it allows the ability for each of these lots to have the potential of building a structure, a dwelling. And so again, there is a reason for the law being the way it is, and this particular date being the date that they established for non-conforming uses. But anyway, again, the parent lot is parcel 25.
Thank you, Mr. Darrow.
Mr. Chair, to add to that,
please.
The fact that we have the appellant basically stating on the record that they think that this is a root lot now without any substantial evidence on that, making a claim on this, we further move to have the board grant our summary judgment and dismiss this case. Thank you.
Thank you, Mr. Planning Director. Are there questions from the board for the parties? I'd like to ask Mr. Sturz a question. Mr. Sturz, you wrote to the board in your petition for appeal on February 6th of 2020. On page 3, the statements to support your belief of why the director's decision was erroneous, arbitrary, or capricious. And item 1 is the one that we've been discussing most recently with Mr. Darrow and Mr. Kern, having to do with your theory about how your parcel exists, and that the change that occurred in 2013 was, in your words, not substantive in any way. Do you believe that the prior landowner of the larger parcel had the right to build the dwelling that you now possess? Could they have built more than one dwelling on the property?
If I can understand your question correctly, you are saying that before the land had been subdivided.
I'm asking, Mr. Sturz, I'm not making a statement, I'm asking a question of you. Do you believe that the prior landowner could have built multiple dwellings on this property?
I understand that. I guess I'm asking, I haven't understood your question, and I'm asking, I was trying to rephrase it for you to tell me whether I had understood it correctly, but perhaps you could just say it again so that I can understand it better. Yes, I apologize that I haven't understood.
Mr. Darrow, what was the original size of the parcel? Do you have that record? Or Mr. Kern? Prior to subdivision?
Again, if you could give me 1 minute and I'll have that information for you.
Because there's another question, Mr. Darrow. Was there an existing dwelling on the parcel prior to 2013?
On Mr. Sturz' parcel?
No, just somewhere in the larger parcel. Was there, this large parcel must have been more than 160 or 200 acres. It must be quite large. Yes,
and again, it might take us a minute or two to get that information for you, but I will find that for you. What I'm doing right now is I'm looking at the size of the different lots, and what I can do is give you those amounts for each of the lots created under this subdivision. So we'll just start with 14-B1, which was 26.8 acres. 14-B-2 was 25.3 acres. 14-B-3 was 73.2 acres. 14-B-4, which I believe is Mr. Sturz' property, is 38 acres. 38.8 acres, and then 14-B-5 is 23.9 acres. So totaling approximately 200, a little less than 200 acres. What I can do is take a quick look and see if there were dwellings on the other lots or on the large lot prior to the subdivision.
Thank you. So the point of this question, Mr. Sturz, is that your argument that there was no substantive change in the use of the property from the 2013 subdivision is the basis of the planning director's decision that was a substantive change, that a subdivision changes the property's function because you can build dwellings on it, you can build buildings on it per parcel based on county restrictions and regulations. So I think that's the core question that the board has to address today, is whether your theory is plausible, and it's something that the board can consider, because we are not charged with making decisions about interpretation of a law. We have to follow the law.
I understand that. So if you could ask me your question again, please.
Do you believe in 2013, prior to 2013, that you could have built your home or your dwelling on the 28 acres that currently exists as your lot? Do you believe that house could have been built prior?
So my house is 38.863 acres. I wouldn't want you to confuse it with a different lot.
Thank you.
And I'm going to answer very honestly and say what I believe I don't think really matters. I think this is all a question of law and fact. And I'm going to answer in that way. I think also, just to respond to Mr. Kern, I was not saying that my lot was absolutely the root lot. I was saying that it was a reasonable assumption to make, and that was all I could say. You know, what I do want to do, what I do hope we can do is follow the law. Mr. Mukai and Mr. Kern have already said that the law doesn't really matter with regard to the rules and regulations, and
I'd like to object to that statement.
I would object to that.
We're both objecting to that statement. We do believe the law matters, and to state otherwise is false. Thank you.
Objection sustained. Carry on.
Nevertheless, to return to that point, there are very clear rules about how STVR registration and NUC certification should be done. These were further confirmed by former director Yee before this board on October 9th, 2020. The rules are very clear, and I think we need to, yes, absolutely address this issue of what was the case before 2013 and after 2013, or before 1976 and after 1976. But we also really do need to address the very clear rules that were established in the granting of registration and non-confirming use certification, and why the planning department now says it just doesn't matter if they follow the rules or not. Because I don't get it.
Thank you. Mr. Darrow. Okay. Mr. Darrow, I see you're back. Do you have an answer to the prior question?
Yes. So we looked at parcel 25. There's no record of a building permit, but there's a record of a building. It's a one-bedroom dwelling. And what happens is if somebody builds a structure on the property, real property tax will assess it, even if it doesn't have a permit. But they're definitely assessing a single-family dwelling on parcel 25. As far as when that structure was built, we don't have a building permit. So again, I think your question in regards to could Mr. Sturz build a house on his property prior to 2013, logically that would, unless he owned parcel 25 prior to that, he wouldn't be able to. He bought the property when it was subdivided into a smaller lot. Thank you.
Thank you.
Mr. Chair.
Yes.
So I'd like to kind of give an example right now based on this concept of missing the deadline. So currently, the short-term vacation rental law is still in effect, right? The non-conforming use side of it has passed. So we have the law saying that if you're in a certain zoning or a resort node, you are allowed to have a short-term vacation rental and you can apply for registration, correct? That exists right now. So if we were to take a parcel that was outside of the zoning, outside of the resort node, and outside of any of the criteria allowed for a short-term vacation rental right now, and an applicant were to submit that application, and the planning department were to miss that deadline, would that then constitute an approval of a short-term vacation rental that wasn't permitted and didn't have a permitted use, didn't have a permitted zoning? That's the question that's essentially before you folks that's being asked. We have that real life situation going on now. We would say no. You applied for something that you never would have even been able to get in the first place. So to have it automatically approved kind of circumvents the system. I mean, obviously there's a larger conversation around this, but in this particular case, it's pretty darn clear. Thank you.
Thank you. Mr. Sturz?
Yes. So what Planning Director Kern is leaving out is that Rule 23-10B states in its entirety, quote, if a decision is not rendered within a 90-day review period, the STVR registration and/or NUC application shall be deemed approved, end quote. That is the law. That is the regulation. To say it's not now is nonsensical and absurd. Back to also what Mr. Darrow had said previously about there being a structure. If there is a structure on one of the lots and it was built without a permit, then the answer to your previous question is, could a structure have been built on my house? Well, I guess on my lot, yes, because anything could be built without a permit and then be accepted by the planning department by its own recognition.
Thank you, Mr. Sturz, but it's somewhat of a tautological argument. Your lot did not pre-exist 2013, and whomever owned the property prior, for them to have built a second structure on their property, they would have had to go through the building department's requirements and the planning department's requirements to establish a second lot of record or to get an accessory structure. And that would not lead to you being able to take possession of that house, that dwelling. So I'm going to go back to the basis of the motion to dismiss, which is that there is an issue of law here, and the law has to do with the 1976 farm dwelling that is specifically stated in our code, and it says in the state land use agricultural district, a short-term vacation rental non-conforming use certificate may only be issued for single-family dwellings on lots existing before June 4th, 1976. And the point of the evidence that's been submitted or the testimony submitted is to determine whether your lot pre-existed June 4th, 1976. I believe that's what's in front of the board at this time. Do any of board members have any other questions? If not, the chair would like to entertain a motion on the planning director's motion to dismiss.
Chair, Justin Lee speaking.
Yes, Justin.
I'll make a motion to grant the planning director's motion to dismiss.
Thank you. Do I have a second?
This is
Second.
Springer Kane. Second.
Okay. That was both Richie Henderson and who else? Well, I'll just take Richie Henderson. I heard him first. So we have a motion from Justin Lee in support of the motion to dismiss. The second was from Richard Henderson, the second. Is there any other questions prior to the vote? Yes. Is that Daniel? Neil?
Is this a two-step process? In other words, if we grant the motion to dismiss, the case is over. But if we deny the motion to dismiss, do we then move forward to a substantive discussion of the application itself?
Well, of the initial appeal, we move on to the appeal. This is a motion to dismiss the appeal. So if the motion carries, then this matter is resolved and we move towards adjournment.
I think I understand it that way, so that if we denied the motion to dismiss, then we can get to the substantive question like has come up with respect to this 90-day rule, and does it automatically get approved even if it leads to a result that wouldn't be legal?
Sorry. That's already been addressed now. Yeah, actually, we've addressed that as well in this discussion as well. But if this motion to dismiss carries, then this matter is over. If it doesn't, we move on to the other elements or aspects of the appeal.
Thank you.
So Neil, if you have any questions on the 90-day rule, this would be the opportunity to make sure they're heard.
I'm troubled by this 90-day rule because it can lead to results that appear to be illogical and contrary to the underlying philosophy of the law. The planning director misses a deadline and therefore something gets put into place that the law doesn't allow. That doesn't make a whole lot of sense to me, but I think a motion to dismiss shouldn't be granted.
Well, please don't advise us of your vote prior to your vote. Let me bring to the board's attention that the reason that this matter is being heard today, rather than continued at the request of the planning director, is because all of these short-term vacation rental matters hinge on these farm dwelling on the Land Use Commission's published decision, which we haven't heard yet. And we don't want to make any decisions that affect the county's position until we hear from the Land Use Commission. However, Mr. Sturz has a novel argument that his lot should be granted that right because of a theory about pre-existing 1976. And so we came here today to hear those arguments. I didn't want to prejudice the board prior by characterizing this matter, but that is the crux of this matter. Yes, we have Mr. Kern.
Thank you, Mr. Chair. Just speaking to the rule, so a law is made, an ordinance is made, which is Bill 108, which is govern the short-term vacation rental. And so when an ordinance or a bill is made, it doesn't go up to the planning department with all of the details and the rules to go together. So what happens next is they put together rules on how they're going to administer and treat this law. So that was what was happened. So the rule is based on the law, is based on the application being supported or in conjunction with the law that was created and how then the planning department would process it. Keeping government accountable, having a rule that says if they don't take action within a certain period of time that it would be granted is something that I don't see a problem with because it's supposed to be based on the law. It's not based on some request outside. It's based on, we meet this criteria based on the law, we're submitting an application and it's being processed. If the planning department doesn't, process it in time, it's approved. It still relates to being in compliance with the law, which is the most important element, and the rules then become how we're administering it. So I think if we're going to say the rule would guide the law, that would get pretty shaky and I wouldn't want to go there. I hope that makes sense. I'm happy to elaborate on it further if it'd be helpful.
Thank you. Any other discussion by the board? Yes, Richie.
I understand that, if I understand what Director Kearns is referring to in this matter, is that an application that is submitted would be defective if it was submitted where the law said it wasn't allowed. And in that case, the application in itself being defective, even if it went past 90 days, wouldn't matter because it wasn't submitted in accordance with existing laws as relate to farm dwellings and single-family residences as they were changed by the 1976 ruling by the State Land Board.
That's accurate from our side.
Thank you. I see a hand raised, yes, in the middle, Mr. Sturz.
Okay, I'm sorry, I didn't realize that I was in the middle on your screen.
Move around us.
We all move around to dance.
This is like Hollywood Square, but different.
Indeed. I'm not sure that I would want to say that the reason that we are meeting exclusively today is exclusively because of what you're calling my novel argument. I think that I have a number of arguments, all of which are equally important, and that the 90-day one is absolutely as important as any other one. It is a rule that was passed. The planning department made a very onerous process, created a very onerous process on applicants, probably to weed out many of them, and is now saying that it doesn't matter how onerous the application process was for the applicant, because if it's the least bit onerous for the planning department, then that's okay because they can skip that rule. And I think that's an important issue because this really gets down to an issue of, is the law being applied equally? And it is not being applied equally, not by any chance. It is being applied in a very arbitrary manner that what applies to the applicants does not apply to the planning department. And that strikes me as fundamentally unjust. The other issue is that I am aware that the Land Use Commission made a ruling in August that was vague and non-specific, and that we are now in the month of March, and there has been no published ruling, and it's unclear when there will be a published ruling, if there will be a published ruling at this point. And I do understand that it's in the planning department's interest to just continue and continue and continue this, but that does create great hardship on applicants who are appealing now, who were once renting their properties as short-term vacation rentals, who bought their properties with the understanding that they could continue to do that because there had never been any statement saying that they couldn't, and now are not able to, and may not be able to until there is a Land Use Commission decision. And frankly, it would seem to me that there would be no harm in allowing those short-term vacation rentals to continue now, to the understanding that that may be reversed at some point in the future if that ever becomes relevant. And not if the Land Use Commission published decision, declaratory ruling, is considered to be both clear, specific, and not a backwards grab, and not unconstitutional in its own as I think, and as many have suggested, may ultimately be the case if this ultimately goes to federal court.
Thank you. You know, in your reference to the Constitution, I'd like to point out that there is a hierarchy that the board always has to allow for, and that's the hierarchy of statute, code, rule, and then policy. And so we're getting down into the policy elements of rules when we start talking about the 90-day element, because I can tell you as the Board of Appeal, we've had scores of appeals on this matter, and most of them are resolved through negotiations with the Planning Department. Some have been continued because of this pause that we've taken so we don't have future conflicts with a definitive declaration by the Land Use Commission as far as what constitutes this farm dwelling definition and construct of agricultural land utilization. From an earlier comment you made where I characterized your argument, and the reason that we're hearing it today is because it's novel, I don't mean that in the fictive sense. I meant nobody's presented this argument to us before, and it allowed for a hearing. So there's no aspersion cast on the use of the word novel.
Okay.
So I hope you understand that.
I understand that. I do also want to just go back to this other issue which I've touched upon in my appeal, which my wife touched upon in her submitted testimony, of the notion of, in the whole issue of agricultural zoning, there is agricultural land that is on lava. There is agricultural land like ours that does not have county water, where the truth of the matter is it's not feasible to plant or to raise livestock without another side way of earning money, of generating money, because we don't have the basic things that you need to do agriculture, which is water. And I don't understand how, on the one hand, the planning department can say this is an agricultural land lot. However, we will not afford it the basic things it needs in order to do agriculture, and how in any way this addresses larger issues of food sufficiency and security that I know that Hawaii wants to promote.
Chair, if I could. Yes. Yes, is that,
Mr. Chair, go ahead,
Springer. Just as a farmer and someone who lives on ag land, I really appreciate your concern and the hardship that causes, but I can tell you that most of the ag parcels on the island don't have water provided. And some, you know, like I'm in a high rainfall area, that works out okay for me, but it is not, unfortunately, a luxury we're all provided. The county doesn't provide water to the majority of agricultural parcels. Wish that were different. That's, I don't think anything that's within the purview of the Board of Appeals, however.
Mr. Chair, we've been
Thank you,
a little over an hour, and I wonder if we could take a break at this point.
Agreed. Thank you, Neil. We will take a 5-minute pause for a good cause. I'll see you in 5 minutes.
didn't connect the question. I just
That was good. I hope it wasn't an awkward time, but I had house guests leaving with my car and they didn't know how to get out of here.
Board, we've been waiting for our council to return,
Sorry, my bad.
and Jay is in the house. So the Board of Appeals, March 12th is back in session. We have a motion to dismiss from the Planning Department. We have a motion on the floor to, from Mr., from Mr. Lee to grant the motion to dismiss. We have a second from Mr. Henderson, and we are in the midst of discussions. So does any board member have anything they wish to discuss or question?
I have a quick question. This is Springer Kate, just on whether it's more appropriate to affirm the motion for summary judgment. Is there a difference in what is established in the record as a result of this decision?
Yes, please. I'm going to ask Mr. Yoshimoto to address that. He's our counsel.
Okay.
Thank you.
Yeah, so the motion to dismiss and the motion for summary judgment basically gets you to the same place. The motion to dismiss obviously dismisses the appeal. The summary judgment basically states that the board has enough information presented thus far to render a decision without going any further. So either path is appropriate.
So with that, what we have in front of us is the motion to grant the motion to dismiss.
Correct, right, yes.
So, yes, Richie Henderson.
This is Richie Henderson, and if the state land use ruling that we're waiting comes out and does an interpretation that would be in the benefit of the appellant right now, would he be able to resubmit an application for non-conforming use if we go ahead and go through with this action to deny the appeal?
Richie, the Land Use Commission has already made their decision, and they've ruled in the adverse to Mr. Sturz' interests. But we haven't seen it published, and so we don't know what the exact language will be, and we don't know if that will have any effect on the county's ordinance that became code. And so that's why we have been continuing all of these matters that are hinged on that question. And again, we're here today because this matter hinges on a different question.
Okay, thank you for the clarification.
Okay. So at this time, if there's no further discussion, I'm going to call for a roll call vote on the motion to dismiss. Yes, Mr. Sturz? Is that you? Mr. Sturz, are you wanting to question something?
I think you need to unmute.
Yes.
Unmute on the WebEx.
Unmute the phone.
No, it's the phone. It's the phone. You, Keiko, need to unmute his phone. The phone number.
Ah.
Or Rob, whoever has the host. The one that has the phone number needs to be unmuted.
This discussion period.
We sent request.
Yeah.
There you go.
No, look at the screen, Keiko. The phone number is still muted.
And you hear me now?
There you go. Thank you.
Mr. Sturz, are you able to hear us?
I can hear you, and I understand you, can hear me.
Yes,
sorry for the technical issue.
Okay, we can hear you now.
So, I want to just say, much like any door, it is not usually hung from one hinge. And I don't think that my appeal today rests exclusively on the single hinge of whether my land changed before and after 1976 or 2013. I think there are the other hinges, including the ones that are brought up by the Land Use Commission and whatever it ultimately publishes.
Thank you. And to clarify, when I use the term a single hinge, what I meant by that is the mechanics of this board's processing of these issues surrounding the short-term vacation rental ordinance have been very narrow, and this is a particular matter outside of that channel. And so, again, I repeat, that's why we're hearing it today. Otherwise, you would have been continued on all the other matters. Now, if we hear you today, we're going to hear you out completely. But as far as this motion to dismiss, I believe it's a question of the law is how this was brought to the board.
So then I do have the same question that Mr. Henderson raised. What happens if and when the Land Use Commission publishes its ruling, and it is clear in its specifics and its scope and its applicability, what it actually means, and it does turn out that it is to my favor? What then?
Yeah, the ruling has been made. We don't think the fine print is going to matter that much, and I certainly can't engage in hypotheticals or speculate on what might happen after that fact. We're dealing with an issue of law, long-standing state statute and ordinance law as to what constitutes a subdivision. And when that subdivision occurred is the crux of the matter, based on law. The arbitrary or capricious nature of the planning director's actions subsequent to that determination are cause for further argument, perhaps. But again, right now, we're dealing with a matter of law. So, is there any further discussion? If not, we'll call for the question. Yes? Is that a question, Neil? Or are you just adjusting your glasses?
I'm adjusting my glasses.
Okay. All right, so we're going to have a roll call vote. April, please.
So we have on the floor a motion to grant the motion to dismiss. Member Lee?
Aye.
Member Henderson?
Aye.
Member Aguiar?
Aye.
Member Kay?
Aye.
Member Davis?
Aye.
Member Thomas?
Aye, Thomas.
And Chair McCulley?
Aye.
You have 7 ayes.
All right.
Passes.
So the motion is passed. The appeal is dismissed. Mr. Sturz, we have you have your future in front of you. We don't know what it brings, but at this time, your appeal is dismissed. Thank you.
Thank you for your time.
Yes. Let's see. So at this time, for the board remaining, we're going to move on to administrative matters. I'd like to ask our Deputy Corp Counsel pinch hitter, Jay, for a status update on the appeals filed with the board.
Oh, you can minutes?
Yeah,
Oh, minutes.
Oh, we've got to approve our minutes.
Yeah.
Thanks. good thing we have a referee in the back. Melissa's pointed out that the first thing to do is to approve the minutes of our December 11th, 2020 meeting. If everybody's had a chance to review, I'd like to ask for a motion to approve the minutes as read.
So moved.
That's by Richie Henderson. And the second?
Seconded.
I'm a second.
Okay, second from Neil. And then any discussion? Okay, let's take a vote. Roll call.
We usually do all in favor, no?
All in favor, say aye.
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 Any opposed?
And any opposed? Same sign. Thank you. Okay, now we'll move on to our administrative matters. Jay?
Okay, thank you, Mr. Chairman. So I've been advised that there are 4 cases currently on appeal. None of them are new, and there are no new actions on any of them. So not much to report other than that status update.
Okay. And then let's ask April for status update of outstanding BOA petitions.
Yes, we have had a number, been notified of a number of cases that have been settled. For the April 9th hearing, right now we have a total of 9 petitions on that agenda. It will be finalized middle of next week, and so we will get that out to you as soon as that is finalized. It's our understanding that there may be 2 of those at this point that may settle, but that is still yet to be seen, and I will keep you posted as the month goes by, which ones are likely to settle and which ones get settled and withdrawn. Just as an FYI, for the May hearing, currently we have 11 petitions on the May agenda, and there are indications that possibly 6 may settle, so there are negotiations taking place. So that's the update that I have today.
Thank you, April. For announcements, I'd like to recognize the Board of Appeals and the Mayor's appreciation for our outgoing member, Steve Hirakami, who has gone on to serve on another board, I understand. I think he's been appointed to the Water Board. So he has a servant's heart, and he continues to serve the county, and we appreciate that. I'd also like to welcome the first meeting for our incoming members, Mattson and Ritchie. And the board members were advised of their coming onto the board and a brief bit about them. And Neil brought up the question of whether the board members should be better familiar with each other rather than how we have our virtual relationships. The issue of the board supporting or promoting familiarity outside of what might occur in our communities kind of bumps up against some of the issues we might be concerned with the public's awareness of the Sunshine Law and how boards of this consequence behave, public perception, because this is a consequential board rather than an advisory board. We're quasi-judicial. So it's important for us to maintain what used to be called Chinese walls, but let's just say we need to behave as Caesar's wife. So at this time, we know who each other are, and just to reference us, an email was sent out on Neil's authorship. It advises what our terms are and our identity. I served through 2022, and as does Springer, and Neil serves through 21. The others are going to survive us. So is there any discussion on this? Neil, are you okay with how we get along with each other?
Let me say I'm very happy to be married to everybody here.
Yes. we have all of our sister and brother wives and husbands.
I hope we all continue without reproach.
Okay. Springer, are you
Chair-
punching some? Yes?
I had another matter I wanted to raise during this announcement section, if I could.
Yes.
And just, I wanted to see if we could, I guess I need to make a motion to petition, to add a petition for rulemaking to a future board meeting. And this would be rulemaking to try to address making sure that our Board of Appeals rules align with the county code and are clearly stated for the benefit of both the appellants and the board members.
I would have to discuss it with you and placing on a future agenda. Yeah, now wouldn't be the time.
Yes.
Under announcement.
Okay.
Yeah.
Yeah, so council has advised the chair that this is something that we will discuss with council and we will put it as an agenda item for a subsequent or a future meeting. Is that acceptable, Springer?
That's what I'm asking, if we could add it to an agenda for a future meeting.
Great, thank you, we will. We'll try to have it on the April agenda according to April. Get it? April. Bam. All right. Let's see, our next meeting date is, again, April 9th, 2021. And with no further announcements, I will entertain a motion to adjourn.
So moved.
Okay. Richie moved, and I believe Stacy gave us a second. All those in favor, say aye, raise your hand.
Aye.
All those opposed, keep your hand down. All right, double shaka. Thank you very much. See you next month.